if we make some mistake or anything like that, don't worry about it.
Sure.
I'll just edit everything out. Okay, great. So
Well, listen, thank you very much for contacting me. I apologize that I'm not able to see you in person, obviously because of coronavirus. That's the only way we can do this session is remotely. So I hope the fact that you're not able to come to my office today in no way inhibits you from asking any questions you want to. And if there's any doubt in relation to anything that I explained to you today, feel free to ask me, or if you want me to clarify it in writing, I'm happy to do that as well.
great. So what the audience has just seen is how a lawyer would have a conversation with a client, how a lawyer might start a conversation with a client online, in making it clear. Why there might be some limitation with the online version. And this is a very good lawyer, obviously very professional man I'm talking with today, Alan Simmons, who is both an attorney in the UK and a legal writing expert. So he's had experience both on the side of being a client, being a lawyer, and being an expert in legal communication, which is what he does with his newly formed company. And would you like to tell us just a little bit about yourself, Alan, and your company and what you do?
Sure. My name is Alan Simmons. I live in Folkestone, which is the south coast of England. I studied law in England, University of Leicester, and also in Strasbourg, France, learning French law, and also at the European University Institute in Florence. And I trained at a magic circle firm in London called Linklaters, and worked as a commercial lawyer for a number of years in some other firms. And I work as a lawyer in a firm called Cassidy's in London. And I also carry on, as Josh said, my business as a trainer, which is online business called alansimmonstraining.com. I carry out both training on oral and writing skills, both in the UK and in other countries in Europe and beyond.
Excellent. So you're an expert in the area of contracts and contract drafting, and this is one of the things where both lawyers and clients get in a real tangle. So let's imagine that I'm wanting to start a business and I need a lawyer to help me draft the contract. What should I prepare in order before I go and see the lawyer so that we don't waste any time? How should I prepare for that?
Well, I think first and foremost, it's very important to decide, or at least to be able to find out what areas the lawyer can help you with. So, for example, you may need the lawyer to help
Sorry,
you.
Could you repeat that?
Certainly.
Yeah, there was a
By all
technical.
means.
Yeah.
So, for example, you might need the lawyer to help you draft employment contracts. So, for example, with respect to your employees, you might need assistance drafting employment contracts. Likewise, you might need assistance if your business is going to grow in terms of acquiring other businesses. So with regard to asset purchase or share purchase transactions. Moreover, you might need assistance with regard to general commercial agreements, such as distribution agreements, which enable you to distribute your products in other countries.
Okay, and so what's the easiest way for me if I'm starting my first business? Let's say I'm starting an online business, and I have 2 employees that I want to hire from the beginning, and I've got some capital from my grandma's inheritance, and I'm ready to go. And so if I look up, is there a resource that I can find this information, or do I need to go to a lawyer first and then tell them? Should I write them an email? What's the easiest way for me to reach out and find out what information I need to bring?
Well, first of all, I think you need to obviously to find a law firm which is suitable for you. Not every law firm will be suitable for you. So, for example, in a startup situation, you probably don't need to go to one of the biggest law firms in the UK or in America, simply because the practice areas that they operate in may not be suitable for you, and this is very important, the fees may be too prohibitive. So first and foremost, it's very important to try and find a law firm which is a suitable size compared to that which you're setting up. And also, it's very important to find a law firm where the lawyers are, dare I say, generalists. So not specializing uniquely in, let's say, banking law or uniquely in antitrust law, that maybe have a broad understanding of the general commercial issues that you as a startup is going to face. So, for example, as a startup business, you might need assistance in drafting employment contracts or advising on employment rights for your two employees. You'll definitely need a website if you're going to be involved in some kind of provision of goods or services online. That can require you to enter into a website development contract, so contracting with a website developer, and that in itself is a significant project which requires a contractual background. So it's very important for us not to forget the services that you want to provide, the goods that you want to sell, are going to be done via the website. So it's very, very important for you to draw up suitable terms and conditions, and for you to also to be aware of the special legal provisions which relate to consumer protection, the origin of which is EU law, which provide a number of things, and perhaps the most important one is the so-called 14-day cooling off period. So if a consumer wishes to enter into a contract with you to obtain services or buy goods, by law, you have to specify in your terms and conditions that the consumer has the chance to change his or her mind within 14 days of entering into a contract with you. So, after that, the situation in which they can terminate may come down to general contractual provisions. I should add one more thing, and this is very, very important. In relation to any kind of contract between yourselves and your customers at the end of the day, or anyone within the context of your business, it's very, very important to consider things which may be an obstacle to you running your business. And the one which obviously comes to everyone's mind at the moment is coronavirus. So the issue of you being unable to perform your work or unable to fulfill your contracts, and this is because of things completely outside your control, coronavirus, where people are located at home, businesses are shut down, factories are closing down, and therefore we need in terms of business to include a clause, very important clause called force majeure, which can provide that in certain situations which are completely unforeseeable, which will make it impossible for a business to perform its obligations under the contract, then they can be excused from their obligations pursuant or under the provision called force majeure. And in order for this to happen, you need to specify what is an event of force majeure. And a number of people nowadays, quite understandably, are trying to make sure that in new contractual relationships, it's very clear that pandemics like the coronavirus are one of the events which will excuse someone from performing.
Okay, great. So let's say that's a great example and really timely, because a lot of people who are clients of law firms and are going to right now seek for damages and seek for arbitration and other kinds of, and even litigation for not being paid and things like that. Let's say I'm in a contractual relationship with a supplier of goods, and the supplier of goods could not supply. Therefore, my business, I couldn't sell my inventory. Let's say it's fruit or something, and they couldn't supply it, potentially because of the government restrictions or whatever. But then I couldn't obviously sell, and therefore my business failed. Now, if this is one of many different situations. So let's just say I'm thinking, this guy never paid me. I didn't get paid. He owed me money, or they were supposed to deliver something, and if they didn't deliver it, I wasn't able to then sell it. What should I do? Should I go to the lawyer? I'm angry. I want to go to litigation. I want to take this guy out. I mean, we were good business partners until coronavirus happened, and then now it happened, and now I found out his true colors, that he's really just a crook. But maybe he is, maybe he isn't. I don't know. But a lot of people are going to be angry. How would I deal with that situation? How would I come with a lawyer? And what would I expect a lawyer to say if I'm a vendor?
I think probably the most important thing is if it relates to a contract that the lawyer you're seeing has not drafted, then obviously you need to show any evidence of the relationship with that person. That's really important. So the actual contract itself, any correspondence, anything to show the relationship.
Okay, so making sure that you have all of the correspondence, all of the information, all of the anything that could be evidence. Evidence means something like documents and or anything recorded. Could be phone conversations, or could be text messages, and of course they're going to need, those things are all included as evidence. And then you're also going to need mainly the contract itself. What do the terms say?
Exactly, that's right. So in other words, the contract, and one thing which is very important to mention is that a well-drafted contract nowadays contains a clause called entire agreement. So if the contract contains an entire agreement clause, it means that the only relevant provisions are those which are contained in the contract. Therefore, we can't look outside to anything else which was said before the contract or any other documents which were provided. So in other words, it only relates to what was actually said in the contract. So allowing the lawyer to see the contract, to analyze the contract, and in particular in the context of coronavirus, to see whether there is a force majeure clause. That's a very important thing, because force majeure is not a concept of English law. So you can have it in the contract or not have it in the contract, but it's really important to see whether there is a force majeure clause, and if there isn't a force majeure clause, then maybe we can rely on some other aspects of English contract law. I'll give you one more example just to let you know what a difficult topic this is. Some years ago, one of the agencies which is situated in the EU agencies, which is situated in England, called the European Medicines Agency, which had entered into a very long contract, I think 25 or 30 years, very expensive, very high level of rent. And when it transpired that the UK was going to leave the European Union, the European Medicines Agencies realised that London was not the best place for it to be, and it wanted to get out of the contract, and tried to argue that the contract was, we call it in English law, frustrated, because something unforeseeable had happened that made it impossible to carry it out. And in fact, the case went to the English Court of Appeal, and the case was dismissed. The claim was dismissed. The English Court of Appeal held that at the time that the European Medicines Agency entered into this long lease, it was foreseeable that perhaps in the near future the United Kingdom could leave the European Union, and therefore they're now stuck with this very long contract.
I see. Now this is an interesting word that you used, perhaps. When a lawyer tells me, perhaps this could happen, perhaps this is the case, perhaps the court will decide. What does that mean? Does that mean 50% maybe, 50% yes or no? Or what when they say perhaps, how likely is that it will happen? I mean,
well, I think perhaps is a very, very imprecise measure of probability. So, for example, if one were to say there is a possibility that perhaps, that doesn't indicate how probable it will be. If one says, for example, it is extremely probable,
okay,
then we're dealing with sort of a 60 or 70%. If we're dealing with a legal term such as on the balance of probabilities, on the balance of probabilities,
on the balance of probabilities,
is a terminology which is used in our legal system to decide a case, a civil case. So one, as the claimant, you must prove on the balance of probabilities, and this is something where the level of proof is not as high as in, for example, criminal cases where you need to show something, you need to prove guilt beyond all reasonable doubt. But going back to your question, perhaps is not a very precise term. So when a lawyer says to you perhaps, you're asking the right question to really indicate what kind of probability, how probable, for example, in litigation, we often use the word, what are the prospects of success? Are they very strong? How strong are the prospects of success?
So if I ask the lawyer, so let's say we have a dispute, whether it's a family dispute, whether it's a criminal case, whether it's a commercial case, and I want to know so I would ask the lawyer, I would use that terminology, what are the prospects of success?
Right. So in that context, when you're referring to civil cases, the lawyer should be able to tell you, well, do we have enough evidence to prove our case on the balance of probabilities? More likely than not. So 51% plus. More likely than not.
But that doesn't mean that we're going to win.
Absolutely not. No, not at all.
Should I pressure a lawyer? Should I say, hey, I need to have more surety. I need to have more certainty. Are we going to win? What's the probability? Can you tell me 90%? Should I give that kind of pressure to a lawyer? What's the lawyer going to do in response if I pressure him like that?
Well, I think it really depends on the situation. Also on the lawyer, but also on the situation. I mean, there are certain cases where the law is clear cut. So let me give you an example. If a customer owes you money, and they haven't.
Okay, could you repeat that again? Sorry, there was a technical cutout. Could you repeat the situation?
You sell goods or you provide services to a customer, and they haven't paid you. Okay, there is no argument that the quality of the goods and services is defective. In other words, the customer does not have an argument to claim against you, a counterclaim, if you will, and therefore the customer also doesn't have a defence to justify non-payment. So if this happens, I'm sure the lawyer can say, well, you will certainly win. When I say certainly win, I mean the court will find in your favour. The court will rule in your favour However, that does not necessarily mean that you'll recover your money, because perhaps, again, the financial situation of the debtor is very bad, and the reason they can't pay you is because they are maybe approaching a situation of insolvency. They can't pay their own debts, and therefore, even if you win, even if the court rules in your favor, you will be known as an unsecured creditor.
Mm-hmm.
Therefore, you come at the bottom of the queue behind other people, such as banks, that have security over the assets of the person you're bringing a claim against.
Now, this is a good, oh, sorry, continue.
What I was only going to say, going back to one of your initial questions, is that before you officially start to bring a claim against the person, you should talk to them. Establish a line of communication. And it's probably better that the lawyer does that on your behalf rather than you, because you are affected by emotion and anger, and therefore that may not be a very good thing for you to be trying to do it yourself. The lawyer can do it in a way which is more dispassionate, particularly if the lawyer is able to establish a dialogue not only with the person that owes you the money, but perhaps their lawyer. And therefore, maybe we can find a way to resolve the dispute which is not going to court. We call this alternative dispute resolution. This may involve something called conciliation, where the parties try and sit down together in a room, or in the case of coronavirus, remotely, and try to talk and find a possibility, a possible solution. Another option is mediation, where you engage a mediator who can try to arrange some kind of resolution between you. And all of these are ways in which you can achieve your goal, that is to say, you as getting your money that you're owed, but not going down a very expensive route, which is litigation, and very time-consuming and very costly.
And so you would say, in most cases, talk to your wife first before you file for a divorce. Or try to go through a route of a mediation or an alternative dispute resolution route before taking it down to litigation, because once you go into the litigation route, it's going to become more and more expensive. And in many cases, or even in most cases, there's no promise or guarantee that you're going to get your money back. So what you would do by going in litigation is you're going to actually create more losses for yourself, and actually could even have a negative outcome. That's basically what the lawyer in most of the time will suggest. But you also mentioned that they could go to bat on your behalf in a dispassionate way.
Yes.
And that is a very important key thing that the lawyer could do. So clients can go to a lawyer and have them as that independent party. Absolutely. That can then now, about who should I trust? I mean, if I say my friend or my cousin says, oh, I know a lawyer, he can help you with that, should I just go to that lawyer that my cousin knows?
Well, I think the most important thing is whichever law firm you instruct has got to be people that you trust. Now, that could well be a law firm or a lawyer that a family member can recommend. However, the most important thing is trust. And trust in the sense of you trust the person who you're instructing, you trust that they will perform in your best interests, plus you trust that they have the required knowledge. Therefore, there's no point in, for example, going to a lawyer who essentially works in the field of divorce if you're trying to bring a claim against a company to recover money. So in other words, the law firm must have the required competence to help you. In other words, they must practice in the area of law which is relevant to your case.
Can I judge them based on their past performance? Is it a good idea for me if a lawyer says, "Oh, I have won 90% of my cases"? Can I trust that if he says that?
Well, I think one could look at it in different ways. If you're going to instruct one of the biggest law firms in the country, then you probably don't need that, because the law firm will be very, very well known through how they appear, for example, in the press. But with a small firm, you may want to say, well, can you put me in contact with any of your past clients? In the same way that when you buy a product online, you look for customer reviews. That's quite common, isn't it? Or when you go to maybe book a holiday, you go on TripAdvisor to find out what other people have thought about the destination that you'd like to go to, the hotel, the restaurant. And I suppose lawyers are no different. The only thing which is slightly different is that they don't have the ability to advertise in the same way. So therefore, you might find testimonials on the website of the law firm. Could well happen that, and in fact, you as a business person yourself, as you're developing your business, it's a very important strategy for you yourself to try to get testimonials of your own customers on your website, because that's likely to encourage other customers to come to you. But very important point I mustn't forget is that testimonials are personal data. So this can also mean something to do with data protection law, which is a very hot topic at the moment, and we must be very careful how we deal with personal data, unless of course we anonymize it, so that we just say this law firm, for example, did a fantastic job, was very, very helpful, business person located in Vienna, for example. So you're not saying actually who it was. But from your perspective as a client, it would be helpful if the law firm was willing to actually indicate a name and contact details of a client. And perhaps what they might do is to ask that client whether they consent to you contacting them, because it will involve passing their personal details to you.
I see. Great. Now, when we were talking a few minutes ago about this, and I won't take you for too much longer because I know billable time. But when we were talking,
in this case, Josh, I have to tell you that with a lot of lawyers, this is a very important point I haven't mentioned. A lot of lawyers very often provide a free initial consultation.
Okay, so tell me about that.
Well, it depends from lawyer to lawyer. I mean, some lawyers they will speak to you on the telephone or see you in their offices and give you, say, a half an hour or 40 minutes of their time without charging. I mean, that can often be the case if you've sent them, for example, some information about a possible claim, and they've already had the chance to evaluate how strong it is. But it varies from lawyer to lawyer. Some lawyers do provide that service. They're under no obligation to do so, but it's worth finding out if they do.
Great. Yeah, great. So
one more thing. Sorry to mention this. It's very, very important when you instruct a lawyer to make sure that they issue an engagement letter. So the engagement letter is their contract with you as a client. So the contract between the client and the lawyer, in the same way that you will have a contract between you and your customers. And that contract between you, the client, and the lawyer, the engagement letter, the lawyer draws up. Sometimes people call it a customer care letter. So it doesn't have to be something as fancy and formal as an agreement, and it will say, for example, the scope of the work. What is it that the lawyer is going to do? What is the lawyer going to do? And this gives the lawyer the chance to give some provisional advice, maybe to make a disclaimer, so to try and limit its liability if the lawyer thinks that the chances of winning, the prospects of success, I think I've mentioned that before, is unknown, is uncertain. And this is again an attempt to try to protect the lawyer from liability in the event that the advice is not successful.
Okay, so I need to. So I get. So let's just go over a few of the basics, and I want to go into a detail on the contracts because this will be very interesting. So basically, what you said is, first of all, I got to go to a law firm that makes sense for what I'm doing. And so if it's a family dispute, I might want to engage people who have a history of dealing with family issues. But if it's a startup company or something that's maybe a small or minor dispute, or I want to do a transaction, or it's something that isn't a lot of money and I want to save money, then I can go to a generalist law firm. That's one of the points that you made. So in choosing in choosing a law firm, I don't necessarily take the advice of my cousin or some random person. I might want to do a little research about that law firm before engaging or instructing that law firm. And there's different ways to do that. But the main thing is that unless I'm a big company or I handle something like a major transaction, I don't want to go to the big name law firm because it's probably going to cost too much money. And they're specialized in things like mergers and acquisitions that the common person isn't. It's not going to be that big of a deal. So first of all, I have to do a little bit of research in finding a law firm for myself, and I can't just take the advice of somebody in my family or friend unless I can trust through their own experience maybe with that law firm or with that lawyer that person handled things well. And then the second thing you said is that I need to prepare all of the documentation that I have, anything, any kind of evidence to show and indicate what to the lawyer that they can build on, because they can't just build on my story. They need to have actual documents. They need to have actual any kind of evidence or information. So if it's a contract, they need to see the contract. They need to see whatever documents you have. If it's a family dispute, if they need to see the bank account records, they need to see where things were coming and going. If it's something that is an issue, you need to have video evidence or anything like that. So the person should bring that to the first meeting, or even before the meeting, send that out to the lawyer if they're communicating via email. And then they have to decide, well, is this lawyer going to give me a free consultation at first and then charge me if I engage them, or are they going to charge me from the beginning? That needs to be clarified between the client and the lawyer. And then when they go into that meeting, if they say, okay, yeah, I like you, we have the prospects of winning the case are high. I think we have a good case. Would you like to instruct me? And then the client says, yeah, let's go forward with this. Then the client should expect an engagement letter.
Absolutely, or it's called a customer care letter.
A customer care letter, and then what else?
Well, I just want to go back because it's very important to mention this. In trying to find a lawyer, one of probably the most efficient ways of doing this is to consult the body which regulates the profession. In this case, in the United Kingdom, it's the Law Society. So you can go to the Law Society's website, for example, and you can try to, through the search engine on their website, to find law firms in different practice areas in different parts of the country, and then from there you can go to the individual websites of the law firms concerned, and that will help you. So in other words, very often in the case of the United Kingdom, or the England and Wales, I should say, the Law Society, it will allow you to do a sort of triage in terms of finding a selection of possible law firms, which will then allow you to do to make some further investigations once you consult the website of the relevant law firm.
Excellent. Okay, so in every country there's going to be a law society or a bar association, and that's where
Yes.
you could find the most reputable sources. Certainly will be members of those associations. Excellent. And then then you're going. Now let's say I bring something to you like this. Let's say that I relied on the person I was doing business with to write the contract, and I want a lawyer to review the contract, and you show me this provision here. It's in the chat bar there. It says the agreement is for an initial term of 3 years, and thereafter will be renewed for further successive 3-year periods, provided that the company is satisfied with the sales of the products by the distributor during the relevant 3-year period. Now, for me as a client, I think that sounds good. I think that they're going to be satisfied. I'm going to be satisfied with the sales. If not, then we close up the business, and there's a termination clause. Tell me from your perspective, what would a lawyer see in this provision, and how would you then explain that to a client?
Certainly.
And then how should the client understand that, and then what should the client do? So go ahead.
Certainly. Well, I think the key thing here is stressing which party that clause favours. So this clearly relates to a distribution agreement, and it relates to the term or the duration of that agreement. So we can see that the agreement is for a period of 3 years, the first 3 years, which is referred to as the initial term, and then may be renewed after that initial term has come to an end. The question is, from the distributor's point of view, under what circumstances will the agreement be renewed? Now, for a distributor, and very often it may well be a small company, startup even, you need to have the confidence that the agreement will continue for a certain period of time in order for you to take the steps to invest in your business. Because if you think that the business will come to an end in a couple of years' time, then maybe it's not worth spending lots of money, or it's not worth taking out long-term loans, it's not worth recruiting lots of staff members, and it's not worth entering into a lease agreement which you're stuck in for many years. So the thing which struck me from the clause that you just described is that the agreement will only be renewed if the company, the one who appoints the distributor, is satisfied with the distributor's sales. The question is, what is satisfaction? As a distributor, how will the distributor know that the company is satisfied? Can we measure satisfaction? I know that Mick Jagger has tried to do it, but that's not necessarily a good measure.
Can't get none.
That's right. So therefore, the problem is that it's very subjective. Company decides at its discretion, the way it wants. The distributor has no input into that decision-making process, and therefore the distributor is likely to hold back on many of the investment decisions I've just talked about, with the result that maybe the business will not grow, and with the result that the sales will not satisfy the company. So it's a vicious circle, if you like. Mm-hmm. So if I was acting for the distributor, I would advise the distributor to try to reach an agreement with the counterparty, with the company, to establish some kind of objective criteria for renewal. So in other words, establishing some kind of targets, some fixed, clear targets, numbers that the distributor knows that if the distributor manages to reach those targets, sell that quantity of the products, the distributor will be satisfied in the knowledge that the agreement will be renewed. And that can be achieved maybe years before the 3-year term ends. The only other thing I want to mention is in the clause that you described, it said that the term will be renewed if the distributor is satisfied with the sales of the distributor during that period.
Mm-hmm.
When does the company take the decision? It doesn't say. Maybe it waits till the final day of the agreement, in which case, if the decision is negative, suddenly the distributor is deprived of its business. Again, that puts the distributor in a very precarious, very uncertain position. So in this respect, it's really important to establish a timeline moving back from the date on which the 3-year period ends to require the decision to be made perhaps at the end of year 2. So in other words, the distributor has to reach the targets by the end of the 2nd year of the term. And if the distributor doesn't reach the targets by that period of time, and let's remember, we already mentioned that the targets will need to be clear and precise. Well, at least the distributor has got another year of the contract in which it can think about what other business it can do when this agreement comes to an end. So there's a kind of breathing space, if you like, for the distributor to perhaps find another business opportunity.
And so the principles that you're acting upon when you are suggesting these provision changes in the legal writing aspect are objectivity, and what else? I mean, obviously, measurability.
I suppose when you're thinking about clauses in contracts, and also not just in writing, but thinking orally, is asking as many questions as you can. So who has to do something? When do they have to do it? How do they have to do it? Why do they have to do it? So by asking as many questions as you can about an obligation of a party or even a right of a party will help to make sure that you are anticipating as many things as possible. And that's got to be a good thing to protect your client's position.
Excellent. Okay, great. Well, thank you very much for this detailed explanation of how a lawyer and a client, how a lawyer serves a client. And I think that you've given a lot of great advice to people that might need an attorney, whether it's for a good reason, like a $1 million contract, or whether it's for a more challenging reason, like dealing with the fallout from the COVID-19 situation.
May I just add one further thing?
Anything you want.
Well, I'm sure you'll appreciate the fact that in the context of this this webinar that we're just conducting for the purposes of communication in the English language, everything that I've said here is for the purposes of communication skills training, and nothing at all constitutes advice. And once more, that's another way that the lawyer will try to limit the lawyer's liability.
Sure, and I think that it's very good advice for one guy talking to the next who might just want to go and get his problem solved from a lawyer, and I really appreciate that. So if you're interested in having online lessons or getting real legal advice and instructing Mr. Simmons, then you can find him at alansimmonstraining.com. That's right?
That's cool. Yes.
Alan Simmons Training, and it's an AlanSimmons training.com. And Alan's a real expert in this area, is known around the world. And obviously, as you can see from this webinar, that he can work with any type of client or lawyer in making sure that their legal writing is at an excellent level, and that nobody's going to have a fallout or that this agreement is going to be good and is going to be written well. So if you do need support with that, you can contact Alan anytime. And I really appreciate the time that you've spent with us today, sir.
Pleasure. Pleasure.
And I hope that you enjoy the rest of the day and the weekend. I don't know. I myself am going to be on lockdown in Delhi,
Me
India.
too. I'm in lockdown as well. I'm in lockdown as well. But one of the great things about lockdown where I live is that we're only 5 minutes walk from the sea, so we can go for a little walk and go to the beach, which is nice.
Oh yes, in the south of England. All right. Well, I'm going to keep you online here for another minute, but just thank you very much for coming on the audience's behalf.
My pleasure. Thank you very much, Josh. Bye.